We're going to have brief speeches from the three panelists, who I'll introduce to you in a moment, and then I will ask questions. You get to ask your questions later on in the day. There are three issues that Robin Knowles has asked us to address. How significant to the rule of law is access to justice for those without means? The next question relates to UN Sustainable Development Goal 16, which says it's to promote peaceful and inclusive societies for sustainable development, provide access to justice for all, and build effective, accountable and inclusive institutions at all levels. And what should that mean for access to justice for those without means in the United Kingdom? And the third question is, in the context of maintaining the rule of law, what's the next practical improvement in access to justice for those without means? The panels are very distinguished and suitable. First, Mrs. Justice Farbey, Dame Judith Farbey, became a High Court judge a little more than a year ago, but 3 months after that, she became President of the Upper Tribunal Administrative Appeals Chamber. She may tell us a little bit about what that does. As a barrister, she specialised in public law, particularly immigration, and she was the first winner of the Bar Pro Bono Award in 1997 for her work for refugees. Simon Davis, nearest to me, was elected President of the Law Society of England and Wales in July. He had been a commercial litigation partner at the London office of Clifford Chance since 1994. He joined the firm in 1982. It's quite unusual for city solicitors to become President of the Law Society, and I think that shows his dedication to working for the profession, its members, and the people it serves. And then we're going to hear from Les Allamby, who is Chief Commissioner at the Northern Ireland Human Rights Commission. He's a solicitor by training, formerly Director of the Law Centre in Northern Ireland, and he will tell us a little bit about Northern Ireland. So that's quite enough from me. I think I'll stay here just so that I can keep an easier eye on the panel. But Judith, why don't you begin by telling us what you would like to say in answer to the questions I've raised so far.
A few words from me about the tribunals. Last year, the senior president of tribunals, Sir Ernest Ryder, delivered a speech in Wiesbaden on diversity and judgecraft, and he stated that it is a constitutional duty of the judiciary to administer justice so that effective access is afforded and procedural fairness is guaranteed. Given the high representation of litigants in person throughout the tribunal system, it's crucial that we get this right. My tribunal, the Administrative Appeals Chamber, deals with a large number of LIPs and a large number of those with protected characteristics under equality law. Around 50% of our cases involve social security claimants, many of whom suffer from long-standing physical and mental health problems. Other jurisdictions within the Chamber generating significant cases include mental health law and special educational needs. And so many of our users and those in other tribunals are vulnerable and require additional support. So I would like, in very brief terms, to suggest 3 practical steps for change. The first is this: how do we make sure that litigants in person understand legal procedures? Many tribunals have individual guidance for their areas and individual policies on how best to support litigants in person. For example, in the immigration context, guidance is sent to LIPs to explain the next steps and to answer common questions that they may have about their appeal. That is a small but valuable step to ensure that they know what to expect when navigating a system which we know they may find hard to understand. But I would suggest that the next step is the development of new practice directions for vulnerable people as a whole, and that should be cross-tribunal so that we have a systemic and consistent approach. Secondly, modifying procedure during the hearing. For those that need it, reasonable adjustments are made for LIPs, for instance, modifying the approach used to obtain reliable evidence. But can we build on the possibility of using different procedures, such as questions in writing, greater use of ground rules hearings, and a more consistent approach across tribunals? And thirdly, physical space. Different tribunals will have different requirements or preferences for their buildings and their hearing rooms, such as a more informal layout than we may find in traditional courts. And I myself saw an excellent model in the Northern Ireland Appeals Tribunal, which hears social security cases in Belfast. Wide doors, simple layout in corridors, good signage, and flexible setup within the hearing room, so that the hearing can be more or less formal depending on the nature of the case. Finally, a very brief word about reform. I know that there have been some concerns among tribunal users about the reform programme and how this may affect litigants in person. But I expect that many litigants would welcome change so that tribunals keep up with their users who can and are entitled to expect a modern tribunal. For those who may not be able to use digital programmes or require face-to-face support, then a service that is appropriate to their needs will always need to be made available. And already, tribunal caseworkers and registrars can and do play a valuable role in giving direct assistance to LIPs who need that assistance. The Senior President of Tribunals is the Chair of the Administrative Justice Council, which is independent of government and independent of the judiciary. And one of its key strategic objectives is to consider how to make the administrative justice system more accessible, fair and efficient. And one of its aims is to consider the impact of modernisation on LIPs. Across HMCTS and across the tribunal judiciary, we are clear that the modernisation of the system cannot be at the expense of those users who are digitally excluded for whatever reason. So in conclusion, the tribunal system has long prided itself on accessibility, and although each jurisdiction varies, the sheer number of litigants in person that we see suggests that we're doing something right. However, that we need to remember that being accessible for the vast majority isn't good enough, and the rule of law means that we need to be accessible for all.
Thank you very much indeed, Judith. Simon Davis, please.
Thank you very much, Joshua. A key part of the Law Society's reason for being is upholding the rule of law. Last year, I chose it as my presidential theme. Little did I know how relevant it was going to be. Let me just start with some good news. I was at the IBA conference in Seoul earlier this year, where we were discussing exactly these issues, and in particular the UN principles and their application. And I was having my leg pulled. I say, well, you Brits, you've come around the world telling us how important the rule of law is. Do you respect it in your country? I said, absolutely. And the evidence I gave, we have a government who overstepped the legal mark, a court who said that what they had done was of no legal effect. The Prime Minister described on live telly as the master of lies, and worse by journalists. And I said, what happened? Nothing. No judges imprisoned, no lawyers tortured, no journalists vanished, which could not be said of many of the jurisdictions that we were talking about at the IBA conference in Seoul. So far, so good. But in terms of the not-so-good news, we have had governments of every hue over the years say how important the rule of law is and how important the system of justice is and the cornerstone of democracy. But I'm a civil litigator, and I've always proceeded on the basis that I'm much more interested in the evidence than what I'm told. And the evidence doesn't back up what those governments have said, because over the years, the Ministry of Justice has always been the poor relation, and it's our job to shine a light into the little nooks and crannies. There are wonderful people in this room doing wonderful things, but it cannot be right that the system of justice relies on lawyers working for nothing to make sure that the system actually works, and that can't be right. Just on one specific, and before I move to the practical, housing. And we all know that this is a holistic issue, but in relation to housing, we're now in a position where some third of the population of England and Wales live in an area with no housing legal aid providers at all, and a further quarter with only one housing legal provider. And we know that if something goes wrong in relation to your house, it's all linked. Debt, homelessness, mental illness, family breakdown. And so it's in relation to that, looked at through the practical lens, that recently I hosted a dinner, Chatham House rules, so I won't even say who was there, but looking around the room, I think just about all of them were there, where we were looking, Joshua, at what practical things we can do. Of course, we're calling for cash, and of course, we're calling for cash to be targeted. But I think there's quite a few practical things which I'm sure you'll be exploring in workshops. The first, take up Judith's point about social benefit, which is such an issue. Make the forms penetrable. Make the forms usable. Make them accessible. Do us lawyers out of a job. We shouldn't have to advise people how to fill in a disability benefit form. And public education, I think, is going to play an absolutely crucial role. You cannot underestimate how many people out there have very little understanding of the system of justice, and no reason why they should. At a recent event, I was told that many people believe that the judiciary includes the police. There are some very, very basic steps we need to be taking so people understand what legal aid is actually still available, how they can access it, and more fundamentally, how can we make sure that they understand what kind of access they can get to professionals to help them on the very early stages of what's going to be a difficult journey.
Thank you very much indeed. Les Allamby.
Thank you, Joshua. I want to start with three brief quotes, starting first with that great legal maxim, what would Atticus Finch say, followed by what do Lord Neuberger and the UN have to say. First, Atticus, you never really understand a person until you consider things from his or her point of view, until you climb into his or her skin and walk around in it. Second, Lord Neuberger, in his Tom Sargent lecture, memorial lecture in 2013, the rule of law can mean different things. First, the rule of law requires laws that must be freely accessible. That means as available and as understandable as possible. Secondly, the laws must satisfy certain requirements. They must enforce law and order in an effective way while ensuring due process. They must accord citizens their fundamental rights against the state, and they must regulate relationships between citizens in a just way. Thirdly, the laws must be enforceable unless a right to due process in criminal proceedings, a right to protection against abuses or excesses of the state, or a right against another citizen is enforceable, it might as well not exist. And then thirdly and finally, the UN and the Rule of Law Declaration, which states that access to justice is a basic principle. In the absence of access to justice, people are unable to have their voice heard, exercise their rights, challenge discrimination, or hold decision makers accountable. And it strikes me that everyone in this audience is part of the rule of law and access to justice, often seeing those concepts through the prism of our own particular role and interests and beliefs. And today we need to develop a holistic view to access to justice and walk in the shoes of everyone involved. Now, in Northern Ireland, the Bar Council has a laudable aim that everyone should be represented in court in civil and criminal proceedings. Yet we know that Article 6 of the Convention can require legal representation in some circumstances, but it does not require it in all civil proceedings. Despite avoiding LASPO in Northern Ireland, we have over 5,000 people going unrepresented each year, mainly in family courts and bankruptcy proceedings. That's before you look at the issue of tribunals. For too long in Northern Ireland, the focus was on the vexatious litigant, of which there are some, but not on the vast majority who surf in and out of legal representation and struggle to break the code of legal language, procedures, and protocols, never mind the complexity of the law itself, which was mentioned by Judith. One of the findings of joint research by the Commission and Ulster University School of Law on barriers to legal participation for litigants in person was the communication gap between, on the one hand, personal litigants and lawyers and judges on the other. But one of the interesting findings of that research was that a personal litigant's perception of getting a fair crack of the whip and having his or her voice heard was often as important as the outcome of the legal proceedings itself. So process as well as substance matters. One of the outcomes as well of the research was the setting up of a litigant in person reference group with equal numbers of litigants in person, experts by experience, with those other stakeholders. So we have a very effective chair, independent, with voluntary sector, private and public sector legal background. We have the judge, who is chairing our Shadow Civil Justice Council. We have representatives from the Law Society, the Bar, the UU School of Law, the Human Rights Commission, the Court Service and the Department of Justice, and as a result we have 8 personal litigants as well sitting around the table. Now the group is in its infancy. It's still norming, forming and even occasionally storming, but to date it's done the following things in less than a year. A range of visits to courts with court service officials in Belfast and Dungannon to produce a report on how to make the courts more user-friendly from personal litigants, raising prosaic but important issues around signage, placement of posters, reception facilities, information in advance of the day. And I'm afraid our courts are nothing like as impressive as our tribunal experience that Judith alluded to. The court service has agreed to deal with some of those former issues quickly, but the systemic issues that have been mentioned, it's agreed to look at working through the latter in time. We have a personal litigant member who's an IT consultant. We have another who's a senior civil servant. We have a third who heads a voluntary organization. These are people with real life experiences and skills and knowledge. So one of those personal litigant members, the IT consultant, is now working with the court service to make the website more user-friendly to personal litigants. We have a working group to look at the issues raised through arrangements from Mackenzie Friends and how and in what way they should be accommodated and regulated. We have a scoping exercise of what services are actually available for personal litigants, and the answer is relatively few in family and bankruptcy proceedings in particular, and perhaps more importantly, a stimulus for a debate on what is needed. We're organising in February, early next year, the organisation of a workshop on dealing with distressed clients through the Access to Justice Foundation, an initiative inspired by Professor Rob Poole's presentation at last year's Civil Justice Council Forum, with follow-up meetings with the Foundation and the Litigant Support Project, who are coming over as well. And again, that's designed to stimulate ideas based on initiatives well established in England and Wales and Scotland. And there's also some follow-up research to the earlier research being led by Professor Gráinne McKeever, who is here today. Now, I don't want to pretend that all of that by itself and the reference group is going to transform the access to justice landscape. It won't. But it might close the communication gap, offer a model for more effective participation, and also have some tangible outcomes and impacts. So in terms of walking in each other's shoes, I'm sure Atticus would approve.
Thank you very much indeed. Thank you, Les. Now, we've got about 10 minutes to talk about the practical suggestions, the ways forward. And each of you in your different ways raised practical improvements. Les, you just referred to how people struggle to break the code of legal language and how the Northern Ireland Court Service website is to be made more friendly. Simon, you referred to making the forms clearer for social benefits claimants. And Judith, you referred to new practice directions for vulnerable people and other changes in procedures and so on. And I want to explore how far one can go in making the court system accessible, particularly online, because that is, as the Master of the Rolls has told us, the future. You can have a very clear web page which asks you a very simple yes-no question, and you answer it yes or no. You provide various names and numbers and details and so on. But the websites of the various different tribunals and courts do not give legal advice. Now, nobody is suggesting that they can tell you, the claimant, the appellant, whether you've got a good case or not. Clearly, you need objective advice on that, and no website is going to do that. But if you look at what the Civil Resolution Tribunal in British Columbia has done, it's able to provide much more information to users, which they're required to at least glance at and then dismiss before they can proceed. and it's possible to explain to people the consequences of bringing a claim, of not bringing a claim, whether you're at risk of costs, what it's going to involve, how much, and all the consequences of that. So the question to all of you is, having heard what each of you have said, how far can we make it easier for litigants in person by giving them more information? Of course, we're talking only about those who can actually cope with online, but that includes those who can cope with online with a friend who can help them through it. But how much more information can we give them to actually help them to use these services best? Simon?
Just focus on, again, just on the most relevant point and some practicalities. The first is we need to be very, very careful not to look at problems through the lens of determination or decision-making or judgments. My own experience as a litigator who has resolved just about every single case throughout my life is that people don't often want a legal determination. What they want is their voice to be heard. They want to look someone in the eye and say, I've been cheated. I've been dealt with in a most shabby, unfair way. And I want you to tell me you accept that and you apologize to me for that. And I want you to put right what you did to me. So in those circumstances, the role of online is going to be ferociously important to make sure that if you haven't been able to sort all those points out by being heard, that there will be efficient processes to get you to the termination. But it must be that way round. The first point is, how do you get your voice heard and how do you get your problems sorted out without having to go through a determination process? So I think the practical point, and there is work being done out there, is to have some kind of visible portal at the very beginning in relation to the most common areas: debt, housing, family, social security, immigration. To say, do you have this problem? Go online. Okay, problem with your neighbor. Or have you done any of the following 6 things? They should not be encouraged to say, here you go, do you think you've got some kind of a legal claim? The first thing could be, have you spoken to the landlord? Have you spoken to the local? Real practical steps at the very beginning with, okay, now you've done all this, and have you spoken to a professional? And if you haven't, I think that's where I would be starting. So the determination is at the end, not the beginning.
Okay, Judith, can the Courts and Tribunals Service provide this, or is it inappropriate for a court to be giving you that sort of practical advice?
Well, it's something that I have to grapple with every day in my tribunal, where we receive a very great deal of correspondence from litigants precisely asking for our advice. And my very skilled registrars go through it and just discuss with me where the precise borderline is between giving practical and administrative advice and between giving legal advice. But in the tribunals, I would venture to suggest we have perhaps a bit of a head start over the courts, in that our standard documentation already explains, at least it does in my tribunal, what the next steps in the case are. And our decision makers, our judges, will produce a very different kind of document to my colleagues in the High Court when they have cases with litigants in person. So we're used to having this, and we're of the mindset where we know that we should and ought to provide information as fully as we can. We're supported by the Supreme Court, who have said that we have a mildly more inquisitorial function in the courts, and I would hope that that sort of thing could be digitalised too.
And can that be extended to the High Court, perhaps not the High Court, but the county courts, the online court, the sort of low-value civil claims that the Master of the Rolls was talking about just now? Or is that inappropriate for that sort? Is there a division between courts and tribunals, and you're helpful and they're more austere?
I think it's probably jurisdiction specific. I think certainly for my tribunal, it's built into the case law that we have to give a certain amount of assistance. It's built into stepping out of social security law, etc. It's built into international refugee law. that courts and tribunals have to give a certain amount of assistance. I don't think I'd like to speak for my colleagues who specialise in very controversial commercial disputes where you literally have a list on one side and a list on the other.
All right, Les, what would you like to say about this?
I think it's part of the answer. I think I'd take a step back. The first thing I think that looking at Northern Ireland, and one of the things we're exploring is actually about the whole procedures of attending court on your own. My experience from tribunals is people still think they're going to court when they go to a Social Security appeal tribunal. And if you put an appeal tribunal in a court, which we still do in some cases in Northern Ireland, that's not surprising. But the first base principle, which could be done for every court, is who are the people there? How do they operate? What is the language that's being used so you can understand before you go in? How does the court system work? What is a call over, etc.? All of that could be digitized very, very simply. Yes, you can certainly do some work around the law and IT. One of the problems in Northern Ireland is we know people surf the internet to try and understand the law, and they nearly always end up picking up law which is in England and Wales, which is different from Northern Ireland. So people often turn up. So we've got to do something about recognising in Northern Ireland, if you're going to have digital availability about what laws say, then those certainly have to be Northern Ireland specific. And my final thing, which was mentioned by Judith about can we make the law simpler? Yes, we can. It's a gargantuan task. I used to sit on the Social Security Advisory Committee. We visited the Tax Simplification Project, which took tax law up there with Social Security law, in my view, as the most complex area of law. And after the event, they were rewriting the existing tax statutes in a way that didn't change the meaning of the law, but actually made the language accessible and more readily understandable. Frankly, we should be starting to do that with all new laws as we go ahead. It's time-consuming, but over time, it's one of those spend-to-save initiatives that the Treasury still occasionally believe in.
Simon, I see you shaking, you're nodding your head in approval. You're nodding.
I'm not certainly nodding in approval. I mean, just by analogy, in the commercial sphere, which I inhabit, often lawyers sit around asking themselves, how do we provide a top-class service to our client? And the first question should be, well, have you asked the client? I think it's going to be really important, picking up Les's theme, is that if you're talking about how do you improve life for the litigant in person, is that you place the litigant in person at the heart of that. And let me give you a good analogy, although it's linked to the recent tragic events at London Bridge. One of the pieces of work which was being done at Warren Hill Police Station in the context of learning together was they asked the prisoners, what would you like to do as your project? And they said, you know, when we arrive in prison, we're given these massive, great rules and procedures and what indeterminate sentence means and tariff and parole and then how you should behave. I can't understand a word of it. So I said, what would you like to do? We'd like to rewrite them. So they're now written by the prisoners. It's completely different. It's got diagrams and language you wouldn't even believe. But now somebody who arrives in prison understands what the rules are. So I'd have your litigants in person right at the front and say, what would help you most? So I would start with them, not finish with them, but start with them, what would help you most in terms of, let's say, document A. Is that a useful document for you as the litigant in person? No. All right, well, how would you rewrite it? So that's where I would start.
And Judith, different procedures, questions in writing, changing the way that tribunals work?
I think it's time we have consistency across tribunals so that we can bring our thinking from our various jurisdictions together. And we can probably learn a bit, I would have thought, from the courts, particularly the family court and the criminal court, where there is now established learning about ground rules hearings and special measures.
Tell us about a ground rules hearing and special measures, because some people may not be familiar with how they work in other areas.
So a ground rules hearing, whether in the criminal context or the family context, is a hearing that happens before the main hearing, before the trial, where the judge sets down rules for how the vulnerable witness or vulnerable party is to be treated. It may involve the use of assistance in the witness box. It may involve, very often does involve, constraining the bar in the questions that they can ask the witness. so that the witness doesn't face challenging cross-examination, but it faces questions which they can understand in simple language. And so the judge will draw up a list of rules dealing with cross-examination, dealing with who will be with the witness in the witness box, and any other measures so that the best evidence of the witness can be provided.
And last question, digital exclusion. I know this is a matter of great concern to tribunal judges at all levels. Is it possible to do what HMCTS wants, which is to provide a digital service, but to ensure that those who find it impossible to deal with computers are helped sufficiently to enable them to do this? And there's also promise that nobody will be excluded and that paper procedures will be available and so on. Is this a circle that can be squared? Does it depend on resources? Are there going to be enough resources? How concerned are we? Les, do you want to say anything about this? And then I'll ask the other panelists. We haven't got very long.
Yeah. My concern, I think, is for the, not just for the, but the digitally excluded. It's where traditionally NGOs, citizens' advice, the independent advice sector, law centres have played a role. And unfortunately, we have unpicked we know the kind of advice deserts. So if we're serious about that, you are still going to need, particularly at tribunals, those kind of services, and you're going to then have to find a way in which those services are not swamped, that they can step back and actually offer something very specific to the digitally excluded. With the best will in the world, I think without that effective network of advice centres, I think it's really quite difficult to properly offer those who are digitally excluded a kind of alternative service.
And Simon?
Yeah, again, I mean, obviously hugely important having the digital facilities, but I'm not sure it's necessarily right to say, well, it's okay, because people won't be forced to use the service. Because I think the reality of life, based on my own family experience, is that what will happen is that people will want to give it a go. They'll give it a go, they'll find they can't sort it out, it's all too complicated, and they'll give up. That's the reality of life, not, oh, I don't want to do it digitally, I want to go and do it myself. That will not be the choice they'll be making. It will be, I just can't cope with this, I will give up. In relation to HMCTS, we raised concerns to them this year that they said, well, what we've done, we've got a telephone helpline for those who've got problems with dealing with the digital service, and they set themselves a target of 3,500 people to be calling. They had 14.
14?
14. And that's because the bill gave up.
Yeah.
And that's your problem, not I won't force people to use it. It's the ones who are using it who will be the ones who can use it are the ones who don't need it. And the ones who need it won't be able to use it. That's your problem.
And what's the answer, Judith?
I'm not sure I've got the answer, but I'd like to make one observation, which is I think we need to be very careful about who is and who is not digitally excluded. Something that I again face on a daily basis are complaints from litigants who have physical disabilities and who desperately want a more digitalised system and who desperately want us, for instance, to send all our bundles by email rather than in hard copy, perhaps because they can't lift those bundles, perhaps because they can't turn the pages of the bundles for physical reasons. And so I've learned since my time in the tribunal not to make any assumptions and to see digitalisation in many respects as something which should facilitate justice.
Okay, Dame Judith Farbey, Simon Davis, Les Allamby, thank you all very much indeed.